Welcome to the Animal Law Podcast. We'll be talking today about a case that was just argued in the 11th Circuit by Delci Winders, who you are probably familiar with. She's been on the podcast before, and she is really one of the most prominent names in animal law. And this case involves an animal who you are also probably familiar with, and that's Lolita, who is an orca, who, in spite of enormous, heroic efforts to help her, both from on-the-ground activists and lawyer activists, and I'm talking for years, yet she still continues to languish in absolutely horrible conditions at this loathsome place, the Miami Seaquarium. Lolita she's really become a poster child for animals in captivity for quote-unquote entertainment. And though, sadly, efforts to date to help her have been totally unsuccessful, the case we will be discussing today holds out the best hope for getting her out of the hideous conditions, or at the very least improving those conditions, and setting a precedent to require that at least endangered species, who are covered by, of course, the Endangered Species Act, be treated more in accord with the requirements of the Act. Before we get to that interview, I'd just like to quickly remind you that running Our Hen House, which produces the Animal Law Podcast, along with, of course, the Our Hen House podcast, which comes out weekly on Saturdays. It's something we really love doing, but it does mean that we have to ask for your support. It does cost some money. And now is totally the time to give that support if you can. Until the end of the year, which is coming up very, very fast, all donations you make, however big or small, are being doubled thanks to a generous pool of donors we call our Barnyard Benefactors. And they're ensuring that any amount we raise up to $20,000 will be doubled. That is an enormous percentage of our budget for the year. And we really rely on this moment in time to raise it. So our Hen House is a 501c3 nonprofit. So your donations are fully tax deductible to the extent permitted by law. So if you have been waiting to donate, this is really the time to do it. Go to ourhenhouse.org/donate. There you can join our special band of supporters, whom we call our flock, or you can make whatever donation you can personally afford and that you're comfortable with. But please do something. If you rely on this podcast, please, we're relying on you. The only way to keep animal-friendly media going is through supporting its efforts. And that means, in this case, Our Hen House and the Animal Law Podcast. Okay, now to Delci Winders. So Delci is PETA's Vice President and Deputy General Counsel for Captive Animal Law Enforcement. She recently completed 2 years as the very first academic fellow of the Harvard Animal Law and Policy Program. She's published extensively, both in academic venues and in the popular press, and she's taught animal law at a bunch of prominent law schools. She'll be talking a little bit about that on our interview. She's also the author of the chapter on animal welfare in the upcoming third edition of the American Bar Association treatise on the Endangered Species Act. So basically, she is the pro. She's the expert on this topic. And I'm so happy to be able to say that also that I have known her since she was in law school. Welcome to the Animal Law Podcast, Delci.
Thank you. It's great to be back.
It is great to have you back. And you are working on a case that really everybody is concerned about. A lot of people are very familiar with the plight of Lolita. I mean, this is an issue that's been going on for a long time, and she has been suffering for a long time. But then there are probably people who are listening who are not. So can you just start by telling us a little bit about her story?
Yeah, Lolita is an orca who is held at the Miami Seaquarium, and she is kept in the smallest orca tank in the world. She has not had the company of a single other orca in decades, despite the fact that orcas are extremely social animals. On top of that, she's confined with dolphins who actually harass and injure her. She doesn't have adequate shelter from the sun, so she suffers injuries from that. And there's been many years' worth of efforts to get Lolita into a better situation.
And describe this tank in a little bit more detail and how bad it really is.
The tank, I mean, it's hard to give it justice. It's really helpful if you can see an image because it's just appalling. I mean, this is really a bathtub for an orca. And not only is it tiny, at its deepest, it's 20 feet. And Lolita is 20 feet long. So she can't dive any depth at all, while her family members in the wild would be diving many thousands of feet deep. She can't swim any distance. It's just a few lengths of her body wide at its widest point, and her family members would swim up to 140 miles every day in the wild. And then on top of that, it's blocked by a large concrete barrier that, of course, Lolita can't swim through, and that it's often blocked off so that she's kept on either one or the other side of that. So she only has a tiny fraction of the tank. And the U.S. Department of Agriculture has been complicit in Lolita's suffering in saying that basically you can disregard this barrier to find that it meets the minimum size requirements of the Animal Welfare Act, which is just outrageous.
And where does she come from?
Lolita was captured in the Puget Sound off the coast of Washington as a young orca. She was between 2 and 4 years old.
And how old is she now?
She's been there for 47 years, so she's most likely a little bit over 50.
And how long do they live?
Orcas can live quite long. Recently, an orca named Granny died in the wild, and she was more than 100 years old. And it's common, assuming they survive infancy, because there is a high rate of infant mortality, female orcas can readily live to be in their 90s.
So what is she, like, this is the Miami Seaquarium, and for people who aren't embedded in this world as you are, they might easily confuse that with SeaWorld, which is much more famous and infamous in its own way. But this is a lot worse than SeaWorld, right?
Yeah. I mean,
a lot worse than even SeaWorld, I should say.
Yeah. I don't want to suggest by any means that the conditions in which SeaWorld keeps orcas is acceptable, but this is even worse. It's a tinier tank. And in fact, representatives from SeaWorld have indicated that they have never known an orca to be kept in such a tiny tank or to be kept without the company of other orcas for such a long period of time. So even as compared to other orcas in captivity, Lolita has it very bad off.
And what does she do there that is so valuable to them? How is she, quote unquote, entertaining people who come to this place?
Lolita is used for shows. She's forced to do tricks and entertain members of the public who sit in a stadium. The members of the public actually have shade while Lolita doesn't, so they're protected by the sun. And that is essentially her life. And she spends a lot of her time engaged in recognized abnormal behaviors, swimming in circles, just floating listlessly in the pool because there's absolutely nothing for her to do. She can't engage in any of her natural behaviors.
All right, so that kind of sets the scene for this really tragic situation. So let's get to the legal story, which has been ongoing for a long time. There have been a number of efforts to get her out of there, both from activists on the ground and also legal efforts. None have been successful, of course, to date. And can you tell us just a little bit about that background and then give us the basic theory of this current lawsuit?
Yeah, so, I mean, advocates have been advocating for Lolita for many, many years, and PETA and the Animal Legal Defense Fund and the Orca Network have really led the charge on the legal efforts on Lolita's behalf, including efforts to challenge the USDA's license to the Seaquarium to exhibit her. And there's actually a pending suit on that issue. But this suit that we're talking about today, and that was recently argued, is an Endangered Species Act suit. And that suit itself goes back many years. I don't know how much detail you want me to get into, but essentially it began when, in 2005, the National Marine Fisheries Service designated Lolita's population, the population she was kidnapped from, as protected under the Endangered Species Act, but excluded Lolita from that listing. And ever since then, there's been an effort to get Lolita the protections she's due under the Endangered Species Act.
So what is the current lawsuit is attempting to get her those protections? What is the theory, the basic theory of this lawsuit? And then we'll go into some detail.
So we were successful in getting her listed, to getting rid of that exclusion. So what that means is that under the law, it is illegal to harm or harass Lolita as an endangered species. And so a citizen suit was brought challenging the Miami Seaquarium's practices and the conditions in which they hold Lolita because they harm and harass her. So that's the basic theory of the case.
And that language, harm and harass, is straight out of the Act, right?
It is, yeah.
Are those terms defined?
They are not defined by statute. The National Marine Fisheries Service defines harm by regulation. It does not define harass, but the U.S. Fish and Wildlife Service, which regulates the Endangered Species Act for land animals, has a definition of harassment. So it gets a little complicated.
Well, everything does.
Yeah.
So how does this apply to captive animals, these terms? I mean, obviously, the Endangered Species Act, most people think of it as applying to animals in the wild. It also applies to captive animals. But can you tell us exactly how?
Yeah, so it's been clear ever since the beginning, and the Fish and Wildlife and the National Marine Fisheries Service have consistently recognized that the Endangered Species Act protects captive and wild animals equally. It's illegal to give them a different status under the statute. So harm is defined by National Marine Fisheries as an act that actually injures or kills fish or wildlife. So that's very broad. It doesn't draw an exception for captive animals, and Fish and Wildlife is the same in that approach. When it comes to harassment, Fish and Wildlife has crafted a regulatory scheme that attends to the fact that, you might argue that any confinement of a wild animal could be considered harassment. So they've basically said, if you're complying with the Animal Welfare Act, and if you're engaged in generally accepted practices, and if you're not harming the animal, it won't be considered harassment. But those are a lot of different standards that you have to meet in order to be accepted.
Yeah, as you just pointed out, there's an and there.
Yes, absolutely.
Yeah. You have to be doing all three of those things.
Yeah. And the Fourth Circuit recently underscored that in the Cherokee Bear Zoo case, Hill versus Coggins, which I know you had Jamie Whitlock on to talk about a while ago.
Yeah, we have actually discussed this issue in a couple of different contexts. And so what court did you bring this case in?
This case was heard in federal district court in Miami, and the district court basically concocted an entirely new legal standard that is not supported by any precedent, and in fact is contrary to Supreme Court precedent. So that's why we appealed that decision.
And let's take a step back and talk a little bit about how the Animal Welfare Act intertwines with the Endangered Species Act here, because I think that's a really huge piece of how you analyze any case involving the Endangered Species Act with a captive animal. And I know that the district court relied on the Animal Welfare Act extensively in this case, but you don't think it's. Am I right that you don't think that the Animal Welfare Act is a significant factor here? Can you explain, or am I right or am I wrong, or can you explain that?
Yeah, you're absolutely right. So our position, and we believe that's supported by Supreme Court precedent that looks at when you have two different statutes that might have some overlap but really address different things, is that the Animal Welfare Act and the Endangered Species Act need to be looked at separately and to each be given their full meaning. So they have different focuses. The Endangered Species Act is aimed at protecting a small subset of animals who are critically imperiled and giving them the greatest protections necessary, and really adopts a precautionary principle. The Animal Welfare Act is a statute that is aimed at protecting a broad swath of animals, but is very clear in that it is providing bare minimum standards. So for many, many years, the agencies responsible for implementing these two acts, the USDA for the Animal Welfare Act and the National Marine Fisheries Service and the Fish and Wildlife for the Endangered Species Act, have worked out schemes to address potential overlaps, including considering compliance with the Animal Welfare Act as one factor in determining when an animal is being harassed, and other methods. So there's no conflict, and the district court invented a conflict between these two statutes in order to try and resolve it. But what that does is really disrupt long-standing practices that have been in place for allowing both statutes to have full effect.
Yeah, so to resolve people's tension about hearing about this standard, So what is the standard that the district court came up with to find that had to be satisfied in order to find that she was harassed?
The district court said that Lolita is only entitled to the protections of the Endangered Species Act if she is, quote, gravely harmed. That term grave has no appearance in the statute, in the legislative history, in anything related to the Endangered Species Act. She invented it, basically. And she did that because she recognized that we had proffered evidence on numerous injuries, in fact, 13 injuries that Lolita is suffering. But because she didn't want to recognize the rights that Lolita is due, she manufactured this standard.
Yeah, can we go through those? I mean, you don't have to go through all 13. But, I mean, we're talking about a motion for summary judgment here, right?
Yes.
So the court wasn't making factual findings here. There was these 13 different ways in which Lolita you were showing evidence that she had been harmed. The court was not accepted that. Is that right, for the purposes of this motion?
Right.
And can you give us some flavor of what she accepted was going on, and she still didn't find out that there was a problem here?
Yeah, I mean, among the 13 injuries, the court noted that plaintiffs had proffered evidence that Lolita was suffering both physical and psychological injuries because she couldn't engage in normal swimming or diving behaviors, even as compared to other orcas in captivity, as I noted before. The court also noted that Lolita has had to have her teeth painfully drilled many times, that Lolita is confined with dolphins who attack and injure her to the point where they make her bleed by raking her with their teeth and sometimes require antibiotic treatment. And the list really just goes on and on.
But the court found that, I mean, it seems to me that these you could argue that the court didn't come up with language, even though it was inventing language for this brand new standard, it wasn't. That sounds like she is being gravely threatened by these harms.
I would submit that the court not only concocted a unlawful standard, but also didn't apply that standard properly. I mean, one of the things the court found was or recognized that we had offered evidence on, is that Lolita's lifespan was shortened because of her conditions at this aquarium. And I would suggest that is the embodiment of grave harm to an animal.
Now, could we go back a second to this? Could you go through to the regulation again? They have to comply with the animal welfare. What is the standard in the regulation?
Yeah, so it's a little bit tricky because we're dealing with the National Marine Fisheries Service, which regulates marine mammals. And so that regulation that I mentioned, the definition of harass that attends to Animal Welfare Act compliance, is actually a fish and wildlife regulation. So the National Marine Fisheries Service does not have a regulation in place and has never explicitly referred to that exception that the Fish and Wildlife Service does. Our position is basically that, you could look to that for guidance because there is no regulatory definition that NIMS has promulgated. And even if you do that, Lolita is clearly being unlawfully harmed and harassed.
Oh yeah, this is getting a little complicated.
Yeah, I'm sorry, but it is.
Well, it is what it is.
There's nothing I can do about it.
So if it were covered, this might be a ridiculous hypothetical, but if you were dealing with that Fish and Wildlife Service regulation, would you be arguing that the Animal Welfare Act had been violated, even though the USDA has not found them in violation of the Animal Welfare Act?
Our position is that regardless of Animal Welfare Act compliance, that exception does not apply to Lolita because the Miami Seaquarium's practices are not, quote, generally accepted. And that's a separate requirement.
Right.
And because they harm Lolita, and that is a separate requirement. We further argue that there is a material dispute of fact as to whether the Animal Welfare Act is being complied with because the U.S. Department of Agriculture itself has been inconsistent in its findings as to whether the tank size, for example, meets its standards. And in fact, the USDA's own Office of Inspector General earlier this year issued a report in which it indicates that the tank is not, in fact, in compliance with minimal requirements.
Jeez. There's a lot of people going to a lot of trouble to keep this poor animal in this tank.
There really, really are. And I should note, I mean, we're talking about the harass definition, but there's a separate harm prohibition, and that, even under Fish and Wildlife standards, does not have any exception for Animal Welfare Act compliance. So we don't even need to get to the harass provision.
Okay. Can you repeat that? I'm sorry.
Yeah, of course. So there are two separate Endangered Species Act prohibitions at issue here: the prohibition on harming an animal and the prohibition on harassing an animal.
Right.
And the definition of harass is the one that gets a bit complicated, as we've talked about, because Fish and Wildlife has adopted an exception when certain conditions, including but not limited to Animal Welfare Act compliance, are met. But the harm prohibition, nobody has ever indicated that there is any exception that includes Animal Welfare Act compliance. Okay. So even if the harass prohibition didn't apply, Lolita is still being harmed in violation of the act.
Well, how is harmed defined, either by regulation or by case?
Harm is defined by regulation as an act which actually kills or injures fish or wildlife. And as we've talked about, the judge recognized that Lolita is, in fact, being injured. And the judge even said, within the ordinary meaning of that term, she is being injured.
So, how did the court resolve that? It said that the ordinary meaning of the term does not apply?
Yes, the court said the ordinary meaning of the term does not apply. And she did that by relying on a dissenting opinion in a Supreme Court decision called Sweet Home versus Babbitt. And the majority in that decision basically said that you cannot narrow the terms that define take in the Endangered Species Act. But the judge bizarrely cited the dissent, and in some instances didn't even acknowledge that it was the dissent that she was citing to.
So why did the court... do you think that the court was mistaken that she was citing to a dissent, or she just thought people wouldn't notice? It's kind of a weird thing to do. Or did she feel that the dissent was like right on this point, even though it differed from the majority on a more central point?
It's hard to say, and I hesitate to speculate because it's so bizarre and illogical. The best I can think is that the judge wanted that to be the standard and was doing anything she could to find support for that, but there is no support that one can rely on for that proposition. As
we said before, this term gravely threatened, like from our point of view, it seems like given this list of dreadful things, of 13th dreadful things that the court agreed, for the purposes of this motion, it would accept as true. Why did the court give any explanation for why this was not enough to constitute a grave threat?
Not really. It was a pretty cursory assertion that even those things did not suffice to rise to the level of a grave threat. So our position on appeal was that not only was an improper standard applied, but the judge improperly resolved material disputes of fact at the summary judgment stage in order to find that standard wasn't met.
Mm-hmm. Now, there's another issue I want to talk about. Well, first of all, is there anything else you want to say on the substantive? Because I want to talk. I know it's weird to put standing at the end of a discussion, but I didn't want to get too sidetracked by it. But is there anything else you want to talk about regarding the substantive issues that I haven't covered?
I don't think so. I think that gets at the core of it, and I know it is complicated, so hopefully we've distilled it down a little bit.
So, as I said, let's talk a little bit about standing. Can you explain the Article 3 standing issue in this case? And I know this is not an easy issue to deal with briefly, but and it's a really hugely important issue. But can you just give us the gist of their argument? Let's limit that to injury in fact.
Yeah. So as most folks listening, or some folks listening, know that under current Supreme Court precedent, in order to have standing to bring a case, you need to have suffered an injury in fact. And under a Supreme Court decision called Havens Realty versus Coleman, the court has recognized that an organization can suffer an injury in fact just like an individual can. And that is suffered when an allegedly unlawful activity essentially thwarts the mission of your organization and forces you to redirect resources to address that fact. And that is the theory on which plaintiffs brought suit here. In addition to, we had an individual plaintiff who suffered an aesthetic injury as well, but that was never addressed by the court because they found organizational injury was sufficient.
And so the court found that organizational injury was sufficient, but the appellee is still arguing that this case, we shouldn't even, probably, because they know that they're a little insecure on the merits.
Yeah.
are arguing that the appeals court should revisit the issue of standing. And can you explain a little bit? I have a lot of trouble with Havens standing. I mean, I don't have trouble with it existing. I just have a little trouble knowing where that line is drawn. And can you explain where they are saying that the line should be drawn, that an organization would not have standing when it has expended resources in order to bring litigation?
Yeah, so the Sequarium basically made a bunch of arguments, all of which the 11th Circuit has rejected, along the lines of, this is a self-inflicted injury, therefore it shouldn't be cognizable for Article 3 purposes. And the 11th Circuit has said, if you're engaging in redirecting resources because of a defendant's unlawful activity, that's not self-inflicted. You're doing that because of the activity that you're trying to address. And we're not going to get into, whether you may have chosen not to expend your resources that way. I do, as a side note, I think it's interesting, this, standing was their primary argument on appeal, but in fact, at oral argument, the 11th Circuit didn't ask any questions whatsoever about standing, and the Sequarium only mentioned one or two sentences about standing.
Is the 11th Circuit, does it have a broader view of Havens standing than other circuits?
It does. It's expressly rejected some of the reasoning that's come from the D.C. Circuit as inconsistent with the spirit and letter of the Supreme Court's decision in Havens itself.
Now, this may be an unfair question, but I'll ask it anyway. So what would be, under 11th Circuit law, what would be a situation in which an organization expends resources on litigation in a way that serves its mission, that would not give it Havens standing? Like what would go on the other side of the line?
What would go on the other side of the line is something that's not being done to address an unlawful activity. So let's use SeaWorld as an example. The orcas at SeaWorld are not listed as endangered. So resources expended on improving the conditions of those orcas would not enter the realm of Havens because we're not addressing unlawful activities.
But if you were bringing a lawsuit, you would be arguing that there were unlawful activity by definition, right? If we were bringing a lawsuit, if there was a congressionally recognized injury, then yes. But essentially resources that are expended on things that are not unlawful, that perhaps you disagree with as an organization and are not consistent with your mission, but are not unlawful or prohibited, do not count towards Havens. So Havens standing is kind of an unsettled area of law, right?
It's definitely in flux. The D.C. Circuit, some of the judges there have raised questions about revisiting the precedent. So yes.
Have you read this decision in Crew versus Trump that came down the other day?
No, actually.
Yeah, it's well,
look at it.
It's definitely, it's a bad decision on Havens standing.
Okay.
Doesn't have anything to do with animals, so we don't have to go into it in detail.
Yeah.
And And I'll tell you, like, I just get confused by haven standing. Maybe that's because, because as you say, and you know a lot more about this than I do, the circuits are different. So I read different things and it seems to get confusing. But haven standing is pretty important for animals, isn't it?
It's extremely important. We usually, in the case books, we see a lot about aesthetic injury for animals and the important decisions in the ASPCA versus Ringling and ALDF versus Glickman, and those are critical decisions. But really, a lot of the cases that are being brought on behalf of animals these days rely on haven standing.
So you mentioned a little bit about the argument, but tell us a little bit more. How did it go?
I hesitate to speculate again about how judges are going to rule, but I feel like it went well. The judges, again, were not interested in the standing arguments that Seaquarium was proffering. So I think that's positive and consistent with the 11th Circuit's reading of haven standing. The court was very interested in talking about the sea pen, the relief that's been suggested for Lolita, which isn't actually in the record at this stage because we are at summary judgment, so we haven't reached questions of remedy. And they spent a fair amount of time on that. I'm not really sure what to make of it because it's not at issue at this point. I'd like to think it's a hopeful sign that the court is really thinking about what the outcome for Lolita is going to be, but I really don't know.
That's really interesting.
Yeah.
That it's not really relevant to the case. But tell us a little bit about it, because I haven't asked you about that. What is the proposed remedy? Yeah,
so as I stressed to the court, there is no one single remedy here. Our argument is that the Seaquarium is violating the Endangered Species Act, and we're asking those violations to be enjoined. And the plaintiff's preferred way for that to happen is for Lolita to be transferred to a sea pen in her home waters where she would be monitored and ensured that her needs are met, but she would also have the ability to communicate with her pod and to have much, much more space than she has at the Seaquarium. But there are other options available as well. The Seaquarium could potentially change its conditions in order to comply with the Endangered Species Act and to stop harming and harassing her. There's also a possibility that they could seek a permit to engage in those activities.
So, God, it really is such a tragedy. Like when you talk about it, like that she can be in this place where she might be able to communicate with her pod.
And her mother is believed to be alive.
Really?
Still.
Oh my God.
Yeah.
Oh
yeah.
God.
So, she could have many more good years if she gets into a good situation.
So, anything more that you want to add about Lolita and the case before we?
Just that I really hope that the court recognizes that this grave harm requirement is totally inconsistent with the act, the legislative history, and Supreme Court precedent, and gives Lolita the treatment that she's due under the law.
Yeah, if this decision is allowed to stand, I mean, it would really change the standard here pretty dramatically. Yeah. I mean, it wouldn't just affect Lolita. This would be a really harmful change to the law.
No, a devastating ruling for all captive endangered animals.
So the last time we spoke, you were doing a fellowship at Harvard. Just before we go, tell us a little bit about all the hats you're currently wearing.
Hard to keep track. I finished up my fellowship at Harvard, so I went back to the PETA Foundation, where I'm now Vice President and Deputy General Counsel for captive animal law enforcement. I'm also continuing to work on publications that I started working on at Harvard and have a number of forthcoming pieces on the Animal Welfare Act. I have a book chapter coming out on the Endangered Species Act and captive animals, actually. And I am about to start a position as a visiting scholar at the Elisabeth Haub School of Law at Pace University.
Very exciting. And yes. Very busy. And so thanks for taking time out of your schedule to fill us in about this case. And
of course.
And where can people stay on top of it?
PETA blogs about it. So I would suggest checking out PETA's blog, and we will be posting updates. And as soon as the court comes down with a decision on our appeal, we'll definitely have an update.
That's great. Thanks so much, Delci.
Sure. My pleasure.
So thanks so much for joining us on the Animal Law Podcast. We will be back next month with a new show. And in the meantime, if you like what you hear here, please subscribe on Apple Podcasts or in your favorite podcatcher, wherever you listen to podcasts, and consider leaving us a good review. And if you are able, please consider making a tax-deductible donation at our henhouse.org/donate. As I mentioned before, all donations up to $20,000 made between now and the end of the year will be doubled by our Barnyard benefactors. So thanks so much for tuning in.